Okay, well, welcome everyone, and thanks for logging on. This is the Immigration Detention Update Review of the Year and Scanning the Horizon, brought to you by the Garden Court Immigration Law Team. The Garden Court's Immigration Law Team is recognised as the preeminent set of barristers in the UK specialising in immigration law. We've been awarded the highest Band 1 status for immigration law by Chambers and Partners, ranked Tier 1 in the Legal 500, the only chambers ranked Tier 1 in immigration law. Garden Court's always also recognised as one of the leading chambers in the UK specialising in civil liberties and human rights. We're ranked in both Legal 500 and Chambers and Partners. My name is Greg O'Kelly KC. I'm a barrister specialising in human rights, asylum and immigration, civil and public law. I'm ranked in Chambers and Partners in the Legal 500. I'm very experienced in immigration detention work. I've been doing immigration detention work now for 15, nearly 20 years. And I do it at every level, from the Supreme Court to the first tier tribunal. I do lots of judicial reviews, bail applications. I do a lot of civil actions as well. I write for McDonald on detention. I write for Buttle Immigration Law Service on detention, and a LexisNexis panel expert on false imprisonment. David Sellwood is going to be speaking today as well. He's a barrister specialising in immigration, asylum, nationality, and human rights law. He acts in public and private law proceedings in courts and tribunals at all levels, including Ceallaigh and the Supreme Court. His expertise includes complex immigration, asylum, deportation, and the citizenship deprivation proceedings, as well as JRs dealing with detention. He's ranked in Chambers and Partners UK Bar Guide. Alex Schymyck is a public law and civil liberties barrister. He's frequently instructed in judicial review cases, particularly urgent, and has significant experience in interim relief applications. Alongside his JR work, he appears in asylum and human rights appeals and has a long-standing commitment to protecting the rights of immigration detainees, as well as doing immigration detention cases. He was instructed on the Brooke House inquiry, and he's written academic analysis on the law of immigration detention as well. Georgina Rea is a barrister with a broad public law practice, recognised for her expertise in housing, immigration, asylum, community care, and education law. She's represented lay clients, statutory appeals before the tribunals, and in complex cases. She's a wide range of experience in immigration law matters, including complex asylum, deportation, human rights claims. Abby Buttle is building a broad human rights, public law and civil liberties practice, specialising in immigration, education and community care. She regularly acts in statutory appeals and bail applications in the FTT. She was my pupil last year, or 2 years ago now, so she's done a lot of complex immigration detention claims and is building a practice in this area. So if we can start the slides, please. That'd be great. Sophie's on the slides today. So the Immigration Detention Update, Review of the Year and Scanning the Horizon. I've been doing this for about 5 years now, maybe 6 years. And the way I've tried to do it is, if you work in immigration detention, the field of immigration detention, the point of this seminar is to cover everything that's happened in the year that's of significance. So if you missed absolutely everything that happened, if you're in a cave or a coma and you didn't know what happened in the past year, what are the things that you missed? We try and cover everything. So next slide, please. So I'm going to look at the top issues from the past year and a practice update. Alex is going to look at accommodation, which continues to be a problem. The bite-sized case law update Abby is going to do. So the idea of that is to cover all of the cases that don't fit into one of the top issues, but are nevertheless worth knowing about. David's going to look at Habeas Corpus in a bit of focus, but that continues to be an important issue. Georgie's going to give us an update on quantum, and then I'm going to come back on horizon scanning. Next, please. So top issues and practice update. Next slide, please. So the issues that I've identified this year, fewer than last year, and probably not as, probably won't have to go into them in as much depth as last year. But Brooke House, the second opinions cases, procedural unfairness, illegal working cases. What I'm talking about there is the consequences of the increased use of raids and the issues that are arising as a result. And then the fourth issue we'll look at is electronic monitoring. Next slide, please. So issue one is Brooke House. Now, presumably you all remember about this, but if you've forgotten or if you don't know, in September 2017, Panorama broadcast film showing really serious ill treatment of detainees in Brooke House. It's really disturbing footage, actually. If you haven't seen it, it's well worth watching. Initially, there was a suggestion there should be an inquiry. The government resisted, and following a case in the High Court, Mr. Justice May held that there should be an inquiry. The Brooke House inquiry heard from 78 witnesses, saw 90 hours of footage, and there was over 100,000 pages of material. And the report was produced in September 2023. It found 19 credible incidents of Article 3 breaches, 19, and made 33 recommendations, one of which was that there should be a 28-day statutory limit on detention. Next slide, please. So you might think things will have inevitably improved. Well, according to a HMCIP report in November 2024, since the previous report, there had been a concerning and substantial rise in violence and self-harm. And there remained a long-standing and fundamental problem that detainees were in effect being kept in an institution that looked and felt like a prison. 35% of those who had been assessed in who given a response to an assessment said that they had been suicidal in the previous year, and medical conditions had actually deteriorated. So conditions and facilities had deteriorated while people were in detention. D1914 was a person who actually was one of the victims of one of those 19 incidents. And he and two other claimants brought a case arguing that the failure of the government to implement those 33 recommendations and rectify the dangerous practices meant that the Secretary of State had breached the investigative and or systems duty in Article 3, that the Secretary of State was frustrating the statutory object and purposes of the Inquiries Act, and that the Secretary of State was acting contrary to legitimate expectation. Next slide, please. Mrs. Justice Lang, however, accepted the government's case that the recommendations by the inquiry had been substantially met and that the government was entitled not to accept the recommendation in respect of the time limit on detention. She also held that there was no legal obligation to comply with the recommendations anyway, and that would not fall within the Article 3 investigative duty. She also held that there was no legal requirement to even respond to the BHI recommendations. Separately, following an intervention by the Speaker of Parliament, she also held that the ministerial statement relied on as giving rise to the legitimate expectation was inadmissible on grounds of parliamentary privilege. The damages claims are transferred to the KBG, and I'm aware that the claimants in that case have appealed to the Court of Appeal, and the appeal is outstanding. Next slide, please. Many of you remember from last year the second opinions policy. In September 2022, the Home Office issued guidance requiring caseworkers to obtain a second opinion where somebody tried to rely on a medical legal report as a basis for being released from detention. That was initially challenged before Mr. Justice Linden successfully on the basis that it was unlawful, firstly because it was contrary to the statutory adult at risk guidance. Remember, when you've got the adult at risk guidance, you've got the statutory guidance under the 2016 Act, but you've also got the policy guidance, which, as Mr. Justice Linden noted, I think Underhill noted, is unhelpfully called the same thing. But it was the statutory guidance that was inconsistent with the new policy. And secondly, because there had been a failure to consult medical justice, it was held that there was a legitimate expectation that medical justice would be consulted because medical justice is statutory in the area and long connection with the Home Office and previous engagement with policies. The Home Office appealed to the Court of Appeal. Next slide, please. The appeal was allowed in part. Lord Justice Underhill held that there was nothing in the statutory guidance that required the consideration of an MLR medical legal report forthwith. It was also consistent with the statutory guidance that a caseworker should be allowed to obtain further information, and the caseworker should have a reasonable period in which so to do. Anything other than a short period, however, would not be reasonable. So if this policy is being applied to your clients, you need to be checking whether or not the period in question is nevertheless a reasonable one. However, the Court of Appeal did uphold Mr. Justice Linden's conclusion that there was a duty to consult medical justice, though that part of the judgment bears careful reading, and it wasn't with an enormous enthusiasm. Next slide, please. The third issue I want to look at is procedural fairness / illegal working. And what I'm really talking about there, like I said, is raids. There has been an increase in enforcement activity, and consequently, there has been an increase in use of certain kinds of powers, including detention powers. And as a result, there have been claims arising thereafter. The key issues are procedurally unfair interviews being carried out in curry houses, being carried out in shops, being carried out in the street. Secondly, the question of whether or not a person is working or volunteering in breach of their visa requirements. See the case of Andrews, which I've referred to on the meaning of that. There's another case, which is I'm involved in, which we're waiting for judgment in, which suggests that Andrews may not be correctly decided on that front, but it's not out yet. Then also obviously the exercise of discretion, which is very important when you're raiding people in a place of work and deciding whether or not you should curtail their leave, and then the use of the correct powers. Next slide, please. So, case of Mohammed Ahmed. This is one of mine as well. Judgment from His Honour Judge Simon. This is an individual who had been in the UK a matter of weeks and was waiting for his job to start and was spending a lot of time with his uncle who owned a curry restaurant. And he was encountered in Birmingham New Street Station and he was considered to be acting suspiciously. So what that means is there was no intelligence involved in terms of the suggestion that people had been working illegally or doing anything wrong. They just went around looking at Birmingham New Street Station, trying to find people who looked a bit iffy. They decided he'd walked away from the immigration officer in a way that suggested he didn't want to speak to them. So they interviewed him in the station on a plastic chair in full view of the public, which is really clear in the photographs that were taken. Now, he wasn't told about the danger he was in and the fact that he might want to think about getting legal representation before answering all of these questions. And in addition to that, rendering the interview procedurally unfair, the circumstance of the interview themselves, so the fact that he was interviewed on a chair in front of loads of people, was itself sufficient to generate procedural unfairness on those pretty unusual facts, and it followed that detention was then unlawful. Next slide, please. The case of Ceallaigh, which I think is how you say it, it's a decision of Deputy High Court Judge Pitaway KC. This was done by Alex Grigg of this parish. It concerned a backpacker who was volunteering at a youth hostel in exchange for food and accommodation, which was in breach of their visa to come as a visitor, although something they weren't aware of, certainly on their case. They were discovered in a raid, and the Home Office failed to follow the relevant policy and consider whether or not to exercise discretion in their favour. It was really clear that the people who were arrested this individual had taken a particular view of what was going on, didn't particularly listen to representations and didn't follow the policy. Again, mirroring some of what was said about what happened in Mohammed Ahmed, the conduct of the officers was described as slipshod. The decision to curtail was unlawful and consequently, again, detention was unlawful. Next slide, please. Case of Corn is another similar case, husband and wife working and studying in the UK. So the husband is working, the wife is studying, and then in a raid, the husband is found, his immigration status is checked. It's discovered that his wife had her sponsorship withdrawn, which she's not aware of. And as a consequence, the Home Office decides to issue both of them red notices, which are what you issue to somebody found working unlawfully, for immediate curtailment and removal, despite the fact that on the policy, she should have been given 60 days leave to get a further job. The curtailment was, further course of study in a CAS. The curtailment was unlawful because it was a breach of policy. There was evidence of predetermination. Again, the people carrying out the raid, just like in Mohammed Ahmed, just like in Ceallaigh, had obviously taken a particular view of what was going on and reached conclusions accordingly. And again, the decision was made with no reasons. The curtailment in that case was unlawful, and again, detention was unlawful. Next slide, please. GPS monitoring continues to be an issue. I've set out there what happened in ADL in 2024. You'll recall Mr. Justice Lavender considered a case brought by 4 claimants released on immigration bail subject to an electronic monitoring condition. There's a breach of Article 8 in 2 of those cases. Condition was disproportionate again in 2 of the 4 cases. Next slide, please. The case of Tascarin was a further case dealing with a similar issue. Again, Mr. Justice Lavender. And this dealt with the question of whether or not a Turkish man who could not be returned to Turkey, absolutely couldn't be returned, could nevertheless be placed on these onerous conditions of bail. And Mr. Justice Lavender held he could not, distinguishing the judgment in Katie on the basis that because there was no possibility of removal, there was no possibility of lawful detention, and consequently there was no power to place the individual in question on bail. He wasn't liable to detention, and consequently the condition was unlawful. And I understand the quantum issues are still outstanding in that case. Interestingly, Mr. Justice Lavender also held that the question of whether or not there's no prospect of removal is one of jurisdictional fact for the court, like in cases like Ceallaigh. Next slide, please. That is everything I wanted to say about the bigger issues. I wanted to talk a little bit about practice because there have been some matters I think are worth knowing about if you don't already. Her Honour Judge Bloom is in charge of the detention cases in the county court. They are all being dealt with by her, and she's case managing them. She held a meeting for practitioners, and some of the issues which came up are as follows. First of all, there are long delays in transferring judicial reviews to the county court, where the only issue remaining is detention, and they need to proceed as Part 7 claims. As a result, if you're asking for a stay to negotiate, you really need to be doing that negotiation during the period you're waiting for the transfer. You're not going to get a lot of sympathy from the court if you've had 3 or 4 months waiting for transfer to happen and then you ask for a stay to negotiate. If you get a county court case number and it doesn't start with 12 and your case is a detention case, please do let the county court know. Because of the fact that around 10% or fewer of these cases appear to be going to trial, the county court has changed the way these cases are being dealt with, although I'll talk a little bit more about whether that'll continue later on. His Honour Judge Dyke is unwilling to issue directions past PTR, that's pre-trial review stage, and also for case management purposes, we're currently only budgeting up to the pre-trial review. The court's concerned that claims need to be properly valued. There has been a pattern of people putting quite low values on claim forms, then later on getting more detailed advice on quantum and applying to raise them. And the court's unimpressed with that and expect people to properly value a claim at the beginning. The court's apparently, we're told, going to be very strict on large budgets incurred pre the first CCMC. So I assume the suggestion is that people are trying to avoid cost budgeting by effectively doing most of the work before the cost budgeting system comes into place. Cases worth £20,000 to £30,000 or less, taking around a day, are being given to district judges, and any appeal will stay in the county court. They will still be multi-track cases. And if you don't think that's suitable for your case, you can ask for another procedure. Next slide, please. Unlawful detention questionnaires or complaints are not being used properly. They're quite useful tools when used properly. The form has now been updated following input that we gave at the practitioners' meeting. It was also said that if you want an extension of time on, for example, particulars of claim, then you need to apply in good time. There's a particular concern that the county court has that we're all wellying these cases into the long grass as soon as they transfer, which is said not to be appropriate. And I can see where the court's coming from on that. The court's also concerned that particulars of claim need to be shorter and tighter. A lot of people who've done a lot of judicial review, barristers, have a tendency to put too much stuff in the particulars to make them too long. And the court thinks that that needs to stop. So you don't need, obviously most people know about this, but if you're pleading particulars of claim, unlike a JR, you don't need to plead evidence. You don't need to plead law. You simply need to state out your case and all the facts you need to rely on. If you don't reply to the unlawful detention questionnaire, you can expect to get an order from particulars and defence in pretty short order. You might get an order from the court for giving you dates that you don't necessarily want to comply with so quickly. So you really should be using that questionnaire. Sometimes the government legal department will want a proper letter of claim where a case has been transferred. So if the only issue is being detention throughout, it may be that both parties will already know where they stand. If detention has been a minor part of the claim before transfer from the administrative court, it may be that GLD will want some details of what you're actually asking for, and a proper letter of claim can be really helpful. If you don't get an unlawful detention questionnaire, having transferred your case from the admin court to the county court, something may have gone amiss. So you should probably contact the court and ask for one, because it may be that they don't have the right address. And I've had a number of cases where people have ended up having to get cases unstruck out where they didn't receive letters from the court. So not getting an unlawful detention questionnaire is a sign that somebody has the wrong address. The court's very keen that you do not transfer the costs of a judicial review from the admin court to the county court. You should be trying to deal with them in the admin court, or providing that cost should follow the event, and you can get counsel to advise on what the right situation is for you in any given circumstances. Any emails to the county court should have the case number in the strap line and be to the inquiries box or to Sandra Besur, who is the clerk to Her Honour Judge Bloom. Next slide, please. If the High Court makes an anonymity order, it will come with you, and there's no need for further application. And Her Honour Judge Bloom would also like to direct, possibly during the PTR stage, that the parties agree a statement of the applicable legal principles in detention cases, because they are complex, but they're also a lot of the time, not all the time, but a lot of the time, they're not really in dispute. Next slide, please. Worth noting for those of you who are claimant solicitors doing damages claims, there seems to have been a change of policy in the GLD in the last few weeks where is a lot less willingness to settle claims. It seems like some of these are going to start going to trial pretty soon, and you need to be preparing cases with that in mind. There seems to be a strong policy shift away from settlement. We'll see if it lasts, but as things stand, it looks like there's going to be a lot more civil actions going to trial in the KVD and the County Court. Worth knowing, there's also a new places of detention direction, which notes the reopening of Campsfield House. Finally, following some great pressure from bail for immigration detainees, the FCT president has written a letter confirming that the first tier tribunal will list bail applications on the day of detention. Those of you who have clients who were involved in, who have had approved premises on the day of release that would vanish the day after release, have noted there's been a real problem in the past. When people missed out on the approved premises accommodation, they'd often spend much longer in detention. And the FTT was previously refusing to list bail applications sometimes on the day of detention. That problem appears now to have been solved following work from bail for immigration detainees and Turpin Miller. I think that is all I was going to say. The next slide, please. I pass you over now to Alex Schymyck.
Great, thanks very much, Greg. Next slide, please. So I'm going to start off with some of the accommodation cases we've had this year. Firstly, looking at the two BLZ cases. These cases arose outside of detention, so the context was someone had been released from detention to unsuitable accommodation, but there is some relevant information for detention practitioners. Firstly, the overall conclusion that if you're in Schedule 10 accommodation, then you're not going to be eligible for Care Act accommodation. And secondly, it's interesting on the fact that the court found a failure to complete a proper safe release meeting prior to release. Certainly in my experience, these release meetings, even though they're required by Home Office policy, almost never happen. So I think it's always worth investigating if you have a vulnerable detainee and putting some pressure on the Home Office to complete that safe release meeting and challenging it if they don't carry it out. Secondly, two interim relief decisions in ARM. This was a case in which there was a really lengthy delay in sorting out accommodation, despite the fact that the claimant was really very seriously unwell, both physically and mentally. The Home Office eventually released the claimant to accommodation which appeared to be unsuitable for the probation requirements, and there was a serious risk of the person being put in breach of their probation requirements. However, the court refused to make a preemptive order to move the claimant to different accommodation. Finally, DJR, which was a case of mine, where unusually the claimant instructed us that he wanted to be released without any accommodation, and we pursued release on that basis. And the court instead made an order for the claimant to be provided with Section 4 accommodation. The primary reason for that was that the court didn't want to order release and potentially put the claimant in breach of his post-sentence supervision requirements, even though he had sort of explicitly said he was prepared to take the risk of being in breach of those requirements in order to avoid going into accommodation he didn't want to. Next slide, please. So for the rest of my part of the presentation, I'm going to talk about non-Home Office accommodation. I found that this year there's been a lot of issues related to accommodation not being provided by the Home Office. Fundamentally, the Home Office don't really understand these other forms of accommodation, and there are often, therefore, very long delays in people being released if this is their accommodation option. The three main sources of accommodation are local authority homelessness support, probation accommodation, and Section 117 aftercare, which is provided by local authorities to people who've previously been detained under the Mental Health Act. And 1 and 2, you need to have access to public funds, but 3 applies to anyone who's been detained under particular provisions of the Mental Health Act. Next slide, please. So firstly, looking at local authority homelessness support, I'm not a housing lawyer, and there's a lot of law about eligibility for homelessness support. The best resource I found is going to the shelter website. They've got a lot of details about who's eligible and sort of the routes for accessing support. So as a first stop, that's really handy. In terms of the rule of thumb for sort of the purposes of representing people in detention, generally the most sort of common situation is where someone holds indefinite leave to remain, they commit an offence, and then the Home Office starts deportation proceedings, and they end up in detention with a stage 1 decision, so they're liable to be detained. But the Home Office hasn't yet made a stage 2 deportation decision and a deportation order, so their indefinite leave to remain remains intact. You also get cases with EA nationals where, again, the provisions are quite complex, where people may still have access to public funds and the possibility of getting local authority housing support. The sort of common issue for accessing the support is you have to demonstrate your own priority need before you actually get a house, rather than just support in accessing other forms of accommodation. Again, the rules around priority need are quite complex, but for our purposes, the main way that detained clients are likely to be eligible and demonstrate priority need is based on their physical and mental health. So evidence that people have gathered under the adults at risk policy often comes in handy when trying to demonstrate priority need. Next slide, please. The big problem with local authority housing support is that people often end up in this catch-22 situation where the Home Office, Tribunal and Probation want the address to be provided first so that it can be added to bail conditions, it can be checked by probation, and they definitely know that the person has somewhere to go on the day of release. The big problem with that is that that's not at all how local authorities work. Local authorities are used to people being homeless, presenting at their offices, and then being provided with accommodation on that day if they're eligible. So local authorities want people to be released from detention without accommodation and then just appear at their offices and be provided with accommodation that way. The difficulty of that situation is that people then spend long periods in detention because the Home Office or the Tribunal are not willing for them to be released without accommodation. Mike Poulter and I had a case like this earlier this year where our client had spent about a year in detention following a grant of bail by the Tribunal, where no one had sort of arranged accommodation from the local authority, despite the fact he was obviously entitled to it. It's a really bad situation, and the Home Office eventually reacted by deciding to try to release him to homelessness. Fortunately, Mike was able to step in and make a homelessness application. We got an injunction to prevent him being released without accommodation, and eventually he was released to local authority accommodation. In due course, the Home Office conceded that their failures to take steps themselves to arrange local authority accommodation breached Article 5 and Article 14. Next slide, please. In terms of the options then for representing clients who are stuck in that catch-22, the first option is to ask for the person to be released without accommodation, and then the Home Office will generally put them in a taxi to local authority offices. Advantage of this is that you can often get it arranged quite quickly, particularly if you can persuade the Tribunal that there's no need for the accommodation to be approved first. Sometimes it's a good idea if you have a probation officer who is on side and they're sort of quite willing to approve accommodation at short notice after the person's been released. The big difficulty of this option is that local authorities often gatekeep in terms of providing homelessness support to people. And if someone who's been in detention arrives at local authority offices, often the staff who are dealing with the situation will not really understand that even though they've been in a detention centre, they still have access to public funds. And there's a risk of them not being provided with accommodation. I've also had issues where people have been released quite late in the day, and by the time they've got a taxi from the detention centre to their local authority, which might be 100 miles away, the local authority's offices have been closed and they've been stuck without accommodation. So it's sort of not always a straightforward option. The second option is to seek an order, including the local authority, as part of the interim relief in the detention claim. The big disadvantage of this is that it can be a bit slower, and sometimes local authorities can still be unwilling to agree to provide accommodation and effectively make you do the first option anyway. But I still think this is usually the best option for clients because it gives a bit more structure around what's going on, and it doesn't rely quite so much on the client themselves explaining the situation when they arrive at the local authority's offices. Next slide, please. The third option is to try and use Schedule 10 as a kind of stopgap option. This is useful in cases where entitlement to the local authority accommodation is in dispute. So you're anticipating there being further housing proceedings, but obviously you want the person to be out of detention as quickly as possible. The difficulty with this option is that it can be a bit difficult to present in court when you're sort of offering the court sort of two different options for how they should make an interim relief order. I also think it's probably quite risky in cases where a client is very clearly entitled to local authority accommodation, because then the court's quite likely to turn around and say, well, you're entitled to local authority accommodation. If they don't provide it, challenge that, rather than trying to get Schedule 10 accommodation, which you shouldn't really get if you've got access to a different form of accommodation. I think it's useful in those cases where entitlement is a bit confusing. I'm waiting for judgment in Petrovici, where interim relief was granted. In those circumstances, where there's an EEA national with quite complex accommodation requirements, and the court ordered Schedule 10 on an interim basis, while there were further proceedings to work out whether the local authority should provide accommodation. Next slide, please. And moving on to probation accommodation. Two main forms of this. Firstly, approved premises, CAS1, which you get if you're a high harm foreign national offender. As Greg mentioned, now the tribunals, often people missing out on this accommodation because they couldn't get bail on the day of their custodial release date, and therefore their approved premises fell away. Hopefully that will become less of an issue as people can get bail on that day and get to approved premises accommodation. The other form of probation accommodation, which is less well known, is CAS3. It's a form of temporary accommodation, and the idea is that it's meant to tide prison leavers over while they arrange other forms of accommodation, whether that is from their local authority or whether that is from friends or family members. It was piloted a couple of years ago, is now being rolled out across the country, but it's not always available in every probation area. The other big difficulty for our client group is that the Ministry of Justice at the moment still insists on you being physically released from prison rather than from an IRC. So they're happy to provide CS3 accommodation if you're detained in prison and get released, but they won't provide it if you are transferred to an IRC, even if it's for 24 hours before release. I've got a case with Mike Poulter, which is pre-permission, challenging that on the basis that it's discriminatory. So hopefully we'll make some progress on that, because the clients who have indefinite leave to remain and have spent quite a lot of time potentially in the UK before being detained, they may well have accommodation options which they can sort out once they've been released, but they need someone to cover them for a short period first. Next slide, please. So finally, looking at Section 117 aftercare. So these are for people who've been previously detained under particular provisions of the Mental Health Act. Again, entitlement can be quite complicated, but I think a generally good rule of thumb is if someone's been detained under the Mental Health Act for more than about a month, they probably would have spent some time under Section 3 and therefore be entitled to 117 aftercare. It continues following release until it's no longer needed by the person, and has to be based on needs arising from their mental disorder. Often detained clients are still eligible for 117 accommodation because they don't have anywhere to go, and often the mental health is deteriorated while they're in immigration detention. So often people have quite strong arguments they should be granted it. I often think it's the best option for people who have been previously detained under the Mental Health Act and have serious mental illness, because you generally get more support if you're in 117 aftercare. It's generally provided as some kind of supported living placement, where so rather than being released from detention to home office accommodation, which is isolated, there'll be a bit more support in place for the client. In terms of difficulties accessing it, often local authorities are really reluctant to actually do anything to provide it until there are court proceedings. I think that's partly because generally 117 aftercare arises in the context of mental health tribunal proceedings, where often the tribunal will make a conditional decision to release, then the local authority will go away and get aftercare sorted, and then they'll come back having it all sorted out and the person can be released from the psychiatric hospital. In order to get around this, I think it's important to get proceedings on foot as quickly as possible. I had a case earlier this year with Halima where we issued and asked for a rolled up final hearing to determine the delay and entitlement to Section 117 aftercare. We got an order for that rolled up hearing about 5 weeks after we issued, and then in the interim period, the local authority quickly got their act together and sorted it out. Next slide, please. So just to summarize then, practical tips for people who might be entitled to non-home office accommodation. So firstly, the key thing is to find out whether the client has indefinite leave to remain or access to public funds on some other ground. Secondly, I think these cases are often quite legally complex, so it's helpful to get early counsel advice and try and work out the accommodation picture earlier on, so then you can progress them in the right direction. And the third thing is that often as the solicitor, it's necessary to do quite a lot of work liaising, coordinating with third parties. The Home Office will not do that work. And you can often achieve great results for clients just by sort of stepping in and liaising between probation and local authorities, etc., to try and make progress. Thanks very much. I will hand over to Abby for the Bitesize cases review.
Thanks, Alex. So I'm going to talk about 5 cases of note from 2025. 2 of these are Court of Appeal decisions and 3 are admin court decisions. There's not really a thread joining any of these cases together, but I do think each of them is helpful to know about on their own terms, as Greg said. So if you could go to the next slide, please. The first case is Geddes in the Court of Appeal. Now, this case had a very long procedural history, so I've included a kind of potted timeline on the slide. But in a nutshell, the appellant was convicted of a serious offence when he was a teenager. He was then served with notice of intention to deport and pursued multiple unsuccessful appeals all the way to the Court of Appeal. Then in June 2017, he gave notice of appeal to the Supreme Court, and it was after this that a deportation order was made. The appellant was then detained for around 2 weeks in immigration detention, and he brought a JR challenging the deportation order. Removal and the JR were then stayed pending the outcome of the application to the Supreme Court, which confusingly took over 4 years, and they eventually refused permission. And that delay is largely unexplained in the case. The JR then came back before the court, the High Court, in January 2025. And the question was whether the deportation order made in 2017 was unlawful because an appeal was still pending as defined by Section 104 of the 2002 Act. And obviously that was important because if it was still pending, then that acts as a statutory bar on removal and making a deportation order under Sections 78 and 79. So the High Court dismissed the claim and the Court of Appeal agreed. And Lord Justice Bean said that Section 104 contains what he described as an exhaustive list of situations in which an appeal is not finally determined, and that applications for permission to appeal to the Supreme Court and leapfrog appeals were not included in this list, so Parliament didn't intend for them to be covered. There was a kind of subsidiary question as to whether that would create an anomaly for the more recently introduced leapfrog appeals, which are possible from the upper tribunal to the Supreme Court. And the Court of Appeal said no. And it gave 2 reasons. The first was that leapfrog appeals are relatively rare. And the second was that in practice, any competent practitioner, it said, would apply for a stay on removal at the point of applying to the upper tribunal for a certificate, which is a precondition for doing a leapfrog appeal to the Supreme Court. So overall, the Court of Appeal found that the deportation order in 2017 was lawful, which meant that the subsequent detention was too. Next slide, please. This is another Court of Appeal decision in Tazim. Tazim was a Pakistani national who had a student visa to study at university in Leicester, which was premised on demonstrating a certain level of English language competency. He was interviewed on arrival at Heathrow Airport, and Border Force officials concluded that he was unable to communicate in English and had concerns over the authenticity of his English language certificates. He was served with notice of cancellation of his leave in the early hours of the morning, and removal was set for later that day. He was effectively detained in what's described as a waiting room in the airport for about 17 hours before he was released. The detention was challenged, as was the lawfulness of the cancellation of his leave by judicial review. And the High Court found that the cancellation of his leave was unlawful on procedural fairness grounds. So essentially, because the Border Force officers hadn't put their doubts about the authenticity of his English language certificates to the appellant. And so he didn't have a fair opportunity to respond to that. The High Court did, however, find that detention was lawful because it was for the purpose of examining his circumstances before deciding to cancel his leave. Now, there was no cross appeal of the finding on the unlawfulness of the cancellation from the Secretary of State. So that finding stood. And for the Court of Appeal, the appellant did appeal the finding on detention. So the Court of Appeal was only concerned with the lawfulness of detention. And in that decision, Lord Justice Mayles held that detention was unlawful from the point of the decision to cancel the appellant's leave. And that was because it was an unlawful decision, as had already been found by the High Court, and therefore it was a nullity. And so the basis for the detention from that point onwards fell away, and reliance was placed on DN Rwanda. The court also gave short shrift to the Secretary of State's argument that a grace period applied here. This wasn't a case where arrangements were needed to facilitate release, so accommodation, for example. So that argument was unsuccessful, and the claimant was awarded £4,500 in damages. So next slide, please. The final three cases are admin court cases. The first of which is Zotto, which involved an asylum seeker who left asylum accommodation without providing a forwarding address to the Secretary of State. So his interview invitation was never sent to him. His claim was then treated as implicitly withdrawn for failure to attend the interview. He was then later convicted of a drug offence and made subject to a deportation order. The claimant brought a JR challenging the deportation order and his detention on the ground that he had an ongoing asylum claim and the withdrawal decision was unlawful. So the central issue for the admin court to decide in this case was what the true construction of paragraph 33C of the immigration rules were on implied withdrawal. But it's important to note that it was looking at the rules as they were drafted in June 2023, so it's changed now. So the court was essentially looking at whether failure to attend an interview included a situation where an invitation was never actually sent because the claimant didn't provide an address, and the judge found that it did. That meant that the withdrawal decision, the deportation order, and the detention were all lawful in this case. And as I said before, it's important to note that under the amended version of the rules, it's now explicit that an application may be implicitly withdrawn if a person fails to provide up-to-date contact details to the Secretary of State. The final two cases are permission and interim relief decisions. Next slide, please. So the first one is the case of BRO. So on the one hand, this is a really complicated case. It touches on some of the issues that Alex just covered as well. But on the other hand, it's also a very unfortunately familiar scenario of Home Office delay in sourcing accommodation for an extremely vulnerable client in detention. While it's only a permission decision, I think it is a helpful one for many claimants in terms of what it means for Section 95 accommodation to be residual in practice. So it was a complex case because the claimant was particularly vulnerable. He was an asylum seeker diagnosed with paranoid schizophrenia with psychotic features, and he'd previously been detained under the Mental Health Act, I think twice, and had been supported by mental health services in England. This was then complicated by the fact that he received a conviction and custodial sentence from a Scottish court in October 2024. His license included supervision and address approval by the Scottish version of the probation officer. And so the case touched on the interaction between the law on immigration detention, Section 95 provision, but also Scottish licence conditions and the support duties that were owed to the claimant from the relevant Integrated Care Board because of the Mental Health Act interaction that he'd had, and also the local authority under the Care Act. So in May 2025, the claimant was granted bail with an address condition. That was about 5 months into his detention under immigration powers. And then the hearing for permission and interim relief was in August 2025, and both were granted. The judge in the case found that delay appeared to have been caused by the Secretary of State's, quote, determination to wait for all possible lines of inquiry on accommodation to be explored and conclusively resolved. If you could go to the next slide, please. I've just included the subsequent paragraph, 41, which I think contains the helpful bit. So it explains that while the judge accepted that Section 95 is intended to be residual and the defendant's exploration of accommodation shouldn't go beyond what is reasonable and realistic, it may not be proportionate to continue detaining a person while turning over every stone to look for accommodation options for him in circumstances where the defendant has the ability to bring about a person's release by offering Section 95 accommodation. So the final case is another successful permission and IR application. If you could go to the next slide, please. This one also concerns delays in sourcing accommodation. It's the case of Karamjeet Singh, who had been convicted of a child sex offence, so his license was obviously more restrictive. He had been detained pending deportation under immigration powers for around 18 months. By the time of the permission and interim relief hearing, he had been granted bail with accommodation conditions 5 months previously, and then he'd been granted bail with those accommodation conditions removed around 7 weeks prior to the hearing. So the claimant's representatives and offender manager took the position that he shouldn't be released until suitable accommodation could be found, not least because if he were to be released onto the streets, he'd obviously likely to be recalled to prison. In his decision, Mr. Justice Linden found that there was a strong prima facie case that the Secretary of State hadn't taken sufficient steps to source accommodation. I think the crucial pinch point in this case was the fact that the FTT had granted bail without accommodation conditions 7 weeks earlier. And it was from this point that the judge found, quote, that it was difficult to see that the defendant has any lawful basis on which to continue to detain the claimant. And linked to this, the judge was also persuaded of the strong arguability of the point that the Secretary of State couldn't rely on the now codified grace period provision to trump the more recent FTT grant of bail. So I think it's an indication that in these sorts of circumstances where the FTT has said that accommodation is not a precondition of release, the Secretary of State may not be able to rely on the grace period provision inserted into the Immigration Act 1971 by the IMA, despite the significant amount of discretion which appears to be baked into the wording of that provision. So just to wrap up that case, the judge granted permission and issued a mandatory order to provide accommodation within 7 days. Those are all the cases at breakneck speed, and I'll pass it on to whoever is next.
Thank you, Abby. I'm going to talk about habeas corpus writs from 2025. It's perhaps the easiest topic to cover for two reasons. The first, only one habeas immigration case arose in 2025, at least reported case. And second, I represented the claimant in that case. So what could possibly go wrong? Before I get to that case, it's probably worthwhile just to have a quick recap on habeas generally, as they are few and far between in the context of immigration. Can I have the next slide, please? The writ of habeas corpus, as we all know, is probably the oldest prerogative writ concerned with the liberty of the citizen under the law. It takes virtually absolute priority over all other court business, and we see that from the case of Ceallaigh from 1991. An application for a writ of habeas corpus is provided for under Part 87 of the Civil Procedure Rules, and in particular, Rule 87.5 sets out what a judge may do when considering an application at a hearing. They may, A, make an order for the issue of the writ, B, adjourn the application to a further hearing, C, direct that the application be considered by a divisional court in the KBD, D, direct that the application continues as an application for permission to apply for judicial review. E, give such other directions for resolution of the application as may be appropriate. F, dismiss the application. Or G, order that the detained person must be released. Next slide, please. Some issues in the context of immigration may be common between judicial review and habeas, but they are very distinct, separate forms of relief. Lord Donaldson explained the difference in Ceallaigh. In that case, the appellant challenged two decisions. The first was the refusal to issue a writ of habeas corpus, and the second was the refusal to grant leave to bring judicial review proceedings against the decision to serve notice of intended deportation. At 894D of the judgment, Lord Donaldson said, a writ of habeas corpus will issue when someone is detained without any authority or the purported authority is beyond the powers of the person authorizing the detention and so is unlawful. The remedy of judicial review, however, is available where the decision or action sought to be impugned is within the powers of the person taking it, but due to a procedural error, a misapplication of the law, a failure to take into account relevant matters, taking into account irrelevant matters, or the fundamental unreasonableness of the decision or action should never have been taken. In such a case, the decision or action is lawful unless and until it's set aside by a court of competent jurisdiction. In the case of detention, if the warrant or the underlying decision to deport was set aside, but the detention continued, a writ of habeas corpus would issue. Next slide, please. Another case shortly after Ceallaigh was Muboyayi, again Lord Donaldson. He gave lead judgment in that case and held that where the right to detain is dependent on a precedent fact or a series of facts, a detention may be mounted, a challenge may be mounted by the means of a writ of habeas corpus. And in particular, see paras 254 to 255. More recently, the Supreme Court considered the writ of habeas corpus, albeit in the context of family law proceedings, where there'd been a court order authorising detention, in the case of the father and Worcestershire City Council. Both Muboyayi and Ceallaigh and the interaction between habeas and judicial review proceedings were helpfully set out in that judgment at paras 55 to 77. Next slide, please. So on to the single habeas immigration case from 2025, the case of Shaheen. The facts were very important. Mr. Shaheen, the claimant, had been born in France to an Irish national and a French national. He did not, however, own an Irish passport. He came to the United Kingdom on a number of occasions and was convicted of a number of offences. Deportation proceedings followed in respect of France, during which he informed the Home Office that he had French and Irish citizenship. He produced his birth certificate, but was told by the Home Office that he needed to get an Irish passport to confirm that citizenship. The Secretary of State subsequently signed a deportation order against him under Section 32(5) of the UK Borders Act 2007 on the basis that he was a foreign criminal under Section 32(1) and 2 of the same Act, namely someone who was not a British or Irish citizen, had been convicted of an offence and had been sentenced to a period of imprisonment of at least 12 months. There was subsequent correspondence between the Irish Embassy in London via prison staff where the claimant was detained, culminating in the embassy confirming that he was an Irish citizen because he was born to an Irish-born parent before 2005, which conferred automatic entitlement to citizenship, with birth certificates merely serving as proof of the same. This confirmation was provided to the Home Office, which in turn corresponded with the Irish Embassy itself directly and received different, and as it turns out, potentially incorrect information about Irish citizenship. The claimant then secured legal representation via the brilliant Mike Poulter at Turpin Miller, and a letter before claim was sent to the Secretary of State, setting out why he was an Irish citizen and including further evidence. Notwithstanding that, the Secretary of State then authorised his detention under immigration powers under para 2(3) of Schedule 2 of the Immigration Act 1971, asserting that he was not an Irish citizen and he was only entitled to become one if he exercised his entitlement by applying for an Irish passport. Further correspondence between the parties followed, and further correspondence with the Irish embassy followed, but to no avail. Judicial review proceedings then followed to challenge the proposed detention under immigration powers, which were due to take effect shortly thereafter, once the custodial element of the claimant's sentence of imprisonment had expired. In the meantime, expert evidence was obtained confirming that the initial position of the Irish embassy, that the claimant was an Irish citizen, was correct. In parallel, an application for a writ of habeas corpus was made on the 3rd of June 2025, and the same day a hearing was listed to take place on that very issue 3 days later, on the 6th of June. The the legal principles were not in dispute between the parties. For detention to be lawful under the 71 Act, the deportation order under the 2007 Act needed to be lawful, which it could not be if the claimant was an Irish citizen. And that question was a matter of fact and law for the court to determine for itself. The outcome, well, at the hearing on the 6th, the Secretary of State maintained that detention was lawful and queried the authenticity of the birth certificate and the claimant's credibility generally. Although the hearing was subsequently adjourned, just before it resumed the following Monday, when the claimant was due to give live evidence, the Secretary of State conceded the claim and released the claimant the same day, I think even perhaps during that hearing, meaning that the writ was no longer required. Next slide. Further thoughts? Well, habeas remains a rarely used remedy to secure release in the immigration context, and that's understandable because it has limitations, not least the narrow scope when compared with judicial review. But the speed within which it works, taking virtually absolute priority over all other court business, is important to remember, particularly when the waiting time for urgent interim relief hearings in unlawful detention JRs can be very lengthy indeed. It's also, as I said before, a fairly streamlined procedure under CPR Part 87. One example of where it could prove very effective is where someone is granted bail by the first tier tribunal and ordered to be released within 72 hours, but is then held beyond that time by the Secretary of State in order for arrangements to be made for their safe release or to fit them with an electronic monitoring tag. In those cases, clearly, the Secretary of State is detaining the person without any lawful basis. Cases like that are akin to prison cases where somebody is detained after the custodial element of their criminal sentence has expired. And I think some of those featured in our detention webinar roundup from last year. So, for example, the case of M.G. King from 2024. And they've carried on, regrettably, into 2025 as well. See, by way of analogy, the case of Babir Bashir and HMP Pentonville from this year. Anyway, food for thought, hopefully. That's it from me.
Thank you, David. Okay, so I'm filling in for Eva on her usual topic. So as she always does, I will start with a quick recap of the principles of quantum before moving on to 2 reported cases from 2025. Next slide, please. I will reiterate what Eva said last year, which is that everybody should read the 2024 decision in Adagrieba. It's really insightful and will definitely help you frame your arguments in your own cases and sets out these principles really helpfully. So now moving on to the principles themselves, I'm sure you all know them really well, and I'll keep this very brief, but just 5 points. First, that there is no requirement that the defendant, so the Secretary of State, foresaw the harm. The Secretary of State does bear responsibility for the loss caused. Secondly, damages are assessed in the round and not by a fixed daily tariff. Third, that the initial shock of detention usually attracts the highest award, with the damages reducing as detention continues. But that principle was questioned in Adagrieba. But I'll come back to that later. Fourth, awards are fact sensitive and whilst quantum cases are helpful illustrations, they don't strictly set precedent. And fifth, causation is key. So if someone would have been detained anyway, despite the public law errors, they can only expect nominal damages rather than substantial compensation. Next slide, please. So when arriving at a reasonable quantum figure, if you are going to compare your case to similar reported cases, do remember to adjust historic awards for two things. So that's for inflation and for the 10% Simmons and Castle uplift. The easiest way to adjust is to use the Lawtel calculator on Westlaw or any other inflation calculator based on the retail price index rather than the consumer price index. The difference between the two is significant, as I realized yesterday when trying to update the two examples below. Those are the same examples that Eva uses every year. So in Thompson, a decision from February 1997, there was a £3,000 award in damages for the first 24 hours of detention. So today, that would be £8,749.40, which is up from last year, which would have been £8,399.60. The second case, to illustrate the point, is MK Algeria, and that's a decision from April 2010, with basic damages being awarded in the sum of £12,500. And today that would be £25,271.40. So as you can see, these adjustments make a massive difference, and always do remember to account both for inflation and the Simmons and Castle uplift, which applies to damages for pain, suffering, loss of amenity, physical inconvenience and discomfort, social discredit, and mental distress. Next slide, please. Great. So before we move on to the 2025 cases, I'll recap Ada Boyega as it was covered in last year's webinar. This was an extraordinary admin court case concerning the unlawful detention of a Nigerian national who was the spouse of an EEA national. He was detained for 88 days at Brook House and received a huge sum of over £200,000. Next slide, please. So as I said to begin with, the full judgment from the 2024 decision is well worth reading, but here are 5 key points to take away from it. The first is fact sensitivity. The judgment questioned the principle that damages reduce over time. Well, in that case, it was because the claimant's psychological injury had stayed consistently high throughout detention. The detention conditions were appalling throughout, and the threat of imminent removal remained persistent. So these 3 factors meant that the damages didn't drop significantly and remained steady throughout the period of detention. The second takeaway is that evidence of poor conditions is really helpful to establishing your case. The Brook House inquiry report can be relevant even where clients weren't detained at Brook House, if you can draw parallels between their detention conditions and the findings set out in those reports. In Adagrieba, the court found treatment that reached the threshold for inhumane and degrading treatment under Article 3. The claimant in that case was detained at Brook House. And the relevant factors included him being locked in a cell for 12 hours a day, lack of privacy and ventilation in the toilets, significant illicit drug use with no attempts to control it, abusive language by staff, and systemic failures, with the breaches being enabled by members of senior management. The third point is to make sure that you plead and particularize all the possible heads of damage from the outset. Many of them succeeded here, and so it might well be worth running them all in tandem if the facts permit it. Fourth, where psychiatric injury was caused by detention, do get expert evidence to that effect. In this case, damages included payment for cognitive behavioural therapy, and that was a treatment recommended in the psychiatric expert's report for the PTSD caused by detention. So that was a really helpful outcome. The fifth point in respect of aggravated damages is to take a broad view of conduct litigation. The judge included the Secretary of State's behaviour at a bail hearing as part of their conduct in litigation. And that's really useful for future disputes, especially where, as we know, bail summaries can contain inaccuracies or there can be a breakdown in communication, often led by the Home Office. Next slide, please. That, however, wasn't the end of the Ceallaigh litigation. As it returned to the High Court at the start of this year, the Secretary of State missed the 29th of September deadline to pay the damages and gave no explanation for the failure to pay. The court ordered interest at 8% from the date of the judgment, so going forward. But the court also considered interest from the date the claim arose to the date of the judgment, and found that some heads of damages, like exemplary damages, Article 3 breaches, wouldn't attract interest for that period, but personal injury, basic and aggravated damages, and loss of earnings would attract interest for the period between when the cause of action arose and the judgment. And all of those the court found would be at 2%. So the total interest before the date that the Secretary of State was due to pay, so before the 29th of September 2024, amounted to £9,648.95. So that's a not insignificant sum just in pre-judgment interest. So this judgment is a useful example of the court's strict approach to enforcement, and it can demonstrate that we should always monitor compliance with orders, as delays can substantially increase the sum owed through that post-judgment interest. And secondly, it helpfully sets out the principles for applying and calculating pre-judgment interest. It sets it out really clearly. So when we're calculating quantum, factor in that potential interest on compensatory heads, which, as it was here, can be a significant sum. Next slide, please. So this is the second reported quantum case of 2025. It's the case of Almas, and it was an appeal from a recorder. The detention lasted only 14 days, but the damages were high, just over £98,000, and this included aggravated and exemplary damages. The claimant was a Pakistani national who'd entered the UK in 2004 and overstayed. Her asylum claim was rejected in 2015 and certified as unfounded. She'd made further submissions in 2015 and 2017, but the Home Office had failed to address the latter submissions at all. Her son was granted refugee status in 2018, and then when she was reporting, the claimant detained her, and she was detained from the 9th to the 23rd of April in 2018. At the 7-day review of detention on the 16th of April, her further submissions, which had been outstanding for over a year, were finally noted, and the removal directions that had been set for the next day were cancelled. However, detention was maintained for a further week until her release on the 23rd of April. So the recorder found, in the first instance, that there had been no consideration of alternatives to detention. The detention records were incomplete, revealing policy breaches, and the risk of absconding assessment was flawed because the claimant had a good history of compliance. The Secretary of State's appeal was dismissed, and the court confirmed that the detention from the 16th to the 23rd of April was unlawful, confirming that the missing or incomplete records undermined legality. A key learning point from this case is that we should be scrutinising all of the detention documentation received either through disclosure or subject access requests. In this case, the detention decision notes were blank, and there was no reason for detention listed at all. And the gatekeeper section was left uncompleted as well. It was noted that removal wasn't imminent on the forms, and the decision maker was still reviewing the file, which should have given the Secretary of State pause. So even if in your case the deficiencies with the paperwork aren't this stark, make sure you plead all of the omissions as well as the positive actions that we say were unlawful. Next slide, please. In Almas, there was also an Article 8 claim regarding the delay in processing her further submissions, which, at least in part, led to her detention. The Article 8 claim arose from the restriction of her rights to private and family life. Whilst those representations were outstanding, she was prevented from working, travelling, and moving freely out of Liverpool due to reporting, and leading her to rely on asylum support. Obviously, that's not strictly the detention part of the claim, but I've just put some notes there for you. So to summarise what I've covered, make sure we adjust for inflation and the 10% uplift, and also consider that pre-judgment interest when looking at quantum, particularly, as Greg said, to be astute to the quantum estimation that we're putting on the claim form. Push boundaries where facts justify it. As we've seen in Accommodation, that showed that established principles in assessing quantum aren't rigid, are fact sensitive. So, for example, the decreasing, the principle that quantum will decrease after initial shock didn't apply there. So that's helpful to rely on. Evidence matters regarding detention conditions, psychiatric harm, and litigation conduct in order to gain all those heads of damages. And gaps in documentation can be powerful, as shown in the case of Almas. And finally, let's all keep an eye on enforcement and take action where payments are late without explanation, because that can lead to an extra 8% interest on that judgment. Thank you very much for everyone, especially Eva, who normally covers this topic. And I'll hand back to you, Greg.
Thank you very much, Georgie. Next slide, please. What's on the horizon? Next slide. So we take this relatively quickly. I would say in relation to Ceallaigh, it's a really good judgment, but in the recent Brook House inquiry judgment D1914, which I referred to at the start, Mrs. Justice Lang suggested that she wouldn't be totally convinced that the Brook House inquiry report should have been admitted as evidence in that case. I think in any future case where you're relying on those conditions, we'd be better off relying on the evidence of the conditions themselves rather than the conclusions of the inquiry on them. In terms of looking forward, we've got this new approach to migration. There are going to be lots of seminars on that in the future. Everything's in flux. One thing I think we can say reasonably confidently is that we're going to be looking at more detention. We're going to be looking at more illegal detention as a result. And there's going to be more work in this field. We still don't know how the IMA is going to be interpreted in terms of Section 12, the hardly distinct limitations. That all still seems to be in flux as well. We're going to see a continuing rise in habeas corpus cases as the Home Office continues to fail to release full and grants of bail. And we also are still seeing cases where prisons are detaining people who they feel that the Home Office might have an interest in. There is a tendency on private contractors to err on the side of detaining people so as not to get in trouble with the Home Office rather than to release people who should be released. We're still waiting for ASK to come out. I've been saying that every year in the update for a few years now, but it still hasn't been handed down. There's a case that Amanda Weston and I have done on home detention curfew release. We're waiting for judgment in that. Mrs. Justice Foster is going to hand down judgment hopefully soonish. And that may potentially have wider ramifications. So it's worth keeping an eye on that one as well. Next slide, please. Apart from that, thank you very much, everyone who spoke today for all your work. And thank you, everyone who came and sat through this during your lunch hour and a quarter. We're sorry it ran over slightly, but we want to get everything in. I hope that was useful for you. And if we don't see you, have a very happy Christmas.